Afternoon, everybody. I am Lisa Poff. I am the project director for the Indiana Deafblind Services Project, and I want to welcome you to this afternoon's virtual workshop on guardianship and able accounts with our presenter, Gordon Holmes. I do just a few things on logistics for you. When you come into the meeting, all microphones are muted and all webcams are turned off. Throughout the session, if you have comments or questions, please feel free to put them in the chat box. Everybody can see that there, and then I'll make sure to watch that so that if Gordon misses it, I can bring it to his attention and he can answer the questions. If you don't see it, in order to access the chat box, there's a toolbar at the bottom of your screen. And then there's a little button that you click on and it'll pop up a new window for you. We are being live captioned today. So if you need captions, you can also click on the captioning button on that same toolbar. We will also be recorded as we go through the session today, and I hope to make that available later on if someone needs it. At the end of the session, I will ask you to complete a session evaluation, and I will put that link in the chat box before the session is over. You'll also get a follow-up email with the evaluation link in it as well. You have to complete that evaluation to get your certificate for the workshop. You'll have till March 1st at 5 p.m. to complete the eval, and then we will email certificates to you the week of March 7th. If you do have any problems technically today, you can reach me at my email. It's lisa.poff@indstate.edu. Or if you're still in and still have some technical problems, send me a message in the chat box. I think with that, it's all up to you, Gordon.
Wonderful. Thank you so much, Lisa. I appreciate the introduction and setup. I'm excited to spend the next almost 90 minutes with everyone. Topics today include guardianship alternatives, and also able accounts, and love questions. So please feel free to enter questions in the chat, and Lisa will be so kind to monitor that and see if we can address your questions perhaps as they come in. So I am a special needs financial planner. Professionally, I'm a CFP, a certified financial planner. My practice primarily focuses on assisting the special needs community with the legal, financial, and government benefit issues faced as a part of the special needs journey. And so I speak at national conferences, state conferences, parent support groups, school corporations, special needs co-ops, and do continuing education for direct service providers, case managers, et cetera. So a lot of speaking, a lot of sharing of my 20 plus years of experience focused on this. In addition to that, I have a 26-year-old on the autism spectrum personally. And so I'm familiar from my personal journey as well as my professional journey in assisting families. My team and I, we have offices in Indianapolis and Louisville. I'm actually sitting in my Louisville office today, but through both the Indianapolis and Louisville offices, we serve families throughout much of the state of Kentucky and the entire state of Indiana. With that said, we'll now move to the first PowerPoint, and I think we'll start with guardianship today, and then we will move from guardianship to able accounts. So I'm going to click share screen and go to the PowerPoint on guardianship. And I trust that everyone can see the PowerPoint presentation there for guardianship. Okay, there we go. All right, so guardianship and alternatives. We are, my team and I, in our special care division, helping families. We work very hard. We're not all things to all people, though. We do have a informal network of attorneys, special needs attorneys throughout Indiana and Kentucky. And so a combination of Our focus on legal, financial, and government benefit issues augmented with the network of attorneys we have. We're able to address estate planning, tax planning, and also appealing government benefit decisions, setting up special needs trust, funding trust asset management, dealing with government benefit issues, et cetera. So usually my days are spent a combination of speaking to groups and then meeting with families all day. And so I've met with a couple of families already here in the Louisville office today. So our agenda for guardianship will be what is guardianship, terms to know, state laws, type of guardianship, types of guardianship, appointing a guardian, liability of a guardian, removal and termination of a guardian, and alternatives to guardianship. So guardianship is a legal relationship between a capable adult, the guardian, and a ward, the protected person, the person for whom guardianship is obtained. In most states, the law presumes that individuals over age 18 can make their own decisions about what is best for them in their daily lives. Some may feel, though, that it is necessary to apply for guardianship to protect their loved one with special needs. There are different types of guardianship, and we're seeing questions come about in real life on this more frequently these days. But there's what's typically referred to as full or complete guardianship versus limited guardianship. Joint guardianship simply has to do with how many guardians there are, how many cooks are in the kitchen, so to speak. Joint guardianship is very common with two parents, either married, divorced, or never married. And again, joint meaning two guardians, and that type of thing. Or in other situations, we may have co-guardians that are siblings or a parent and a sibling. So we'll talk more about joint guardianship in a moment, but let's start on the left with full guardianship. So full guardianship is the most comprehensive approach to take to guardianship. Comprehensive decision-making authority and responsibility over personal and or legal and financial affairs. So with full guardianship, it is also typically referred to as guardianship of the person and guardianship of the estate. So the person, guardianship of the person has to do with being guardian of their presence, where they live, their activities, what's going on with their physical personage. And so we say guardian of the person. Guardian of the estate is where one is over their financial and or legal dealings. So to go to court to get full guardianship means both of these elements are rolled in together. That is guardianship of the person and guardian of the estate. Years ago, it was most common to see guardianships being full or comprehensive. And then in recent years, as we have moved in a direction of self-advocacy and taking more of a minimal approach, it's more common to see simply guardianship of the person. But there are some situations that arise where if a parent or whoever is guardian is only guardian of the person, that there are those limitations as financial issues may arise, meaning you went to court, you obtained guardianship of the person, but not the estate. And now perhaps the individual with special needs has money. They have money because they got a job. They have money because someone made a gift to them, or family did a GoFundMe type of arrangement, or a grandparent, great aunt or uncle passed away and left them money as a part of their estate plan. Or they did some sports betting and they had a winner come in. So there are, of course, all manners in which monies might flow to any individual, including an individual with special needs. Again, if the guardian had gone to court to obtain guardianship of the person and not the estate, then the guardian would not have authority over or be able to help with the financial resources, because that's not what their guardianship included. So one needs to be thoughtful when they approach guardianship to determine if full or limited is appropriate, and what circumstances may lie in the future. Because if one obtains guardianship of the person and not the estate, and then financial issues arise, they may find themselves having to go back to court to expand on the guardianship to full guardianship instead of guardianship of the person only. And of course, they can only hope that at that point there is not a contested or a conflicted guardianship situation. So at any rate, that's full versus limited. Limited, again, in the middle being responsibilities typically of either the person would include medical. So if you have guardianship of the person, then you have guardianship over medical issues, their physical whereabouts, their traveling, their where they reside, government benefits that they're receiving. So guardianship of the person does provide a great deal of authority, but it simply is limited to those areas. It does not include being the oversight of their financial issues. Also, being a guardian of the person does not automatically provide for that person to be the representative payee on the Social Security benefit. So again, there are some reasons for getting full guardianship if needed or appropriate, or issues anticipated in the future. For joint guardianship, the most common, of course, are where parents, either a single parent or two parents on a joint basis, go to court to obtain guardianship. Once they have guardianship, then guardianship is maintained indefinitely. Indiana statute does allow for the county court where guardianship is awarded. And again, it's the county seat in every county at the courthouse, either in person, when we, as increasingly we're getting back to in-person hearings and so forth, or virtually, guardianship is awarded. Then that county court where the guardianship was awarded by state statute can require a reporting back to them. What we see most commonly is after 1 year, and then each 2 years are on a biannual basis going forward. Not all counties require it, and so literally it can depend upon which county you're in as to whether any report to the court is required. I've seen some counties where guardianship was awarded 20 years ago, and there is yet to be a single report going to the county court. So again, every county is different in terms of how they implement or require compliance with the state statute. In addition to guardianship between two parents, it is also possible to have guardianship other combinations, and that can be a single parent and an adult sibling of the child with special needs. It can be two siblings as joint guardians. So there are a variety of options to pair two people together to be guardian. But in the state of Indiana, you go to court to obtain guardianship, and so a judge has to issue the guardianship order. So wanting to be guardian or simply being a biological or a custodial parent is not tantamount to being guardian. Now, guardianship typically kicks in at the age of 18, but there are circumstances where guardianship may need to be obtained at ages other than 18. So examples are, in the event we had a parent or parents that became disabled or died, then family, whoever is designated in the will or estate plan, or whatever consensus the family comes to as to who should serve as guardian, would then petition the court to be appointed the legal guardian for the minor. And then that guardianship would be retained until the minor reaches the age of majority. So again, if parents become disabled and simply cannot serve as a parent, or parents pass away, this type of thing, or certainly in some instances, if a parent were to be incarcerated, this type of thing, then someone else would need to become the legal guardian. And the process usually starts with petitioning the court. And petitioning the court would differ depending upon whether you're pursuing juvenile guardianship or adult guardianship. So juvenile guardianship, again, is most often obtained in situations where we have a foster care parent that's becoming the guardian. We have parents that have passed away or become disabled or cannot serve as guardians, this type of thing. So those are instances where individuals would go to court to obtain guardianship, and special needs or a diagnosis is not required. Once a child reaches age 18 and adult guardianship is being petitioned from the court, that's when we look for a diagnosis, a disability, basically reasons for the guardianship and the inability of the protected person to tend to these things for themselves. Now, guardianship obtained as a minor expires when the protected person turns age 18. So if a guardianship is obtained when they're 12 or they're 13 or this type of thing, then it terminates at age 18. In many cases, the guardian will petition the court to have the record reflect the termination of guardianship. However, if guardianship as an adult is appropriate, then whoever is pursuing guardianship, most often a parent, can petition the court as their child is approaching age 18 to request guardianship, that is petitioning the court, the judge, to award guardianship as an adult to said parent. And then you can have situations where guardianship is obtained at yet older ages. So guardianship is from birth to death, just depending upon the circumstance. A minor guardianship can be obtained for a minor, for an adult, guardianship of the person, guardianship of the estate. Sometimes minors, parents, actually biological parents that are automatically guardians to oversee them, have to go to court to become guardians of the estate of the minor person because they have inherited or they've come into money. So as you can see with the juvenile versus adult, the full versus the limited, the joint versus individual, you start getting into a number of different combinations with the guardianship issue. And so for that reason, it truly is helpful to seek some counsel or advice on whether to or not to pursue guardianship. Then, of course, you do have some situations where if the child is 18 or over, they may contest the guardianship, in which case the court is likely to appoint a guardian ad litem to represent them. So that complicates things a bit. And then sometimes we actually have spouses or at one time spouses kind of competing for guardianship, now divorced, this type of thing. And so we have one parent wanting to become the sole guardian when the other parent has not forfeited their parental rights. So yeah, so it's good to get good counsel. As I mentioned, we have an informal network of attorneys throughout Indiana. And so we have the capacity to help pair families with attorneys to give legal counsel and advice, as well as to provide legal assistance in pursuing guardianship if that's the direction indicated based on that family's situation. Okay, I want to remind everyone that questions are not only allowed, but they're encouraged and welcome. So feel free to put a question in the chat box and we'll be happy to address it. Okay, so appointing a guardian requires proof to the court that the person is not able to care for himself or herself, or able to look after him or herself or their own affairs. Physician certification is required. So you have to have certification from a physician certifying diagnosis and therefore the appropriateness of the guardianship proceedings. All interested parties must be notified. So this includes all parents, and even expanded beyond them. But all parents being, all interested parties being notified, of course, is a part of why it is not possible for one parent to pursue guardianship of especially an adult child without the other parent being aware. So the other parent may be okay with it, may not be okay with it. People sometimes lawyer up. Every situation varies. Court appoints someone to represent the individual during the court proceedings, and that varies by county. Some counties, like Marion County, will appoint a guardian ad litem. Some counties do not. The guardian ad litem represents the minor or the ward, the protected person, where typically, most situations, the interest of the parents is being served as a result of legal counsel, the attorney the parents have secured to assist them with the guardianship process. Guardians' powers in dealing with the person's property are carefully restricted by law. Okay, looks like we may have a question. Let's see. And okay, yes, contact information will be the last slide actually of today's presentation, and I'll make certain to have that up for a while so you can take a picture of it, that type of thing. I'm always happy to provide a free consultation to families or parents, that type of thing. I meet with typically on average anywhere from 30 to 40 parents a week or families a week. So it's a fairly rigorous schedule. I have hours during the week, during the day, occasionally an evening if I'm not speaking to a group. And then we also have some limited Saturday hours. So we make great effort to accommodate people and their availability. In-person meetings occur either at the Indianapolis office or Louisville office. Louisville is great for pulling in people from Mount Vernon, Evansville, Warwick County, New Albany, all the way clear over to Lawrenceburg. And then people, families, of course, in Kentucky. Indianapolis, pretty much everyone, Seymour North usually comes to Indianapolis, and we have families that a lot by Zoom these days, but we do have families that will come in from Crown Point or Angola or you know where to come for help because of our knowledge and expertise in these issues. All right.
Gordon, we did have a question about whether they could get a copy of the PowerPoint.
I see. Well, so great question. And the answer to that question is I do provide a free follow-up consultation. And during the consultation, what I can do is provide a PDF of the slides. Unfortunately, the presentation itself is proprietary and I'm unable to provide the actual PowerPoint presentation. The other reason for that, of course, is that the PowerPoints could be modified and then I would kind of have all kinds of things out there. So, but if someone does want a copy of the slides, then I would suggest taking advantage of the free follow-up consultation, and that would be a logical point to get email address or information from them and provide that for them. These presentations change usually at least once, if not twice a year, because government benefits change, there are legal changes and so forth. So that's the other issue, in that they become dated relatively quickly. And so that's why I'm always happy to return and provide the updated knowledge and information and presentation. Also, I am going to get electricity. I've been operating on battery and I'm seeing the brightness start to be affected. So I do beg your indulgence while I plug in. Here we go. Okay. Wonderful. Thank you for that. All right. There we go. Liability of a guardian. These questions come up frequently. People actually, they want to know, if I'm the guardian, does that mean I'm responsible for everything they do? If they get into trouble, am I in trouble right there with them? If they were to commit a criminal offense, does that make me a suspect? How does all that work? So a guardian must use reasonable care and caution when making decisions and doing things on behalf of the protected person. Unless a guardian acts negligently, though, unreasonably or irresponsibly, they're generally not personally liable for any of the actions taken on behalf of the protected person. A guardian may be held liable for his or her actions where the protected person's property is damaged due to careless acts of the guardian, or if the guardian is personally at fault. So, sometimes people get upset and that type of thing, but if, as an example, if a guardian were to move the protected person's furniture outside and we had rain like we did today and it was all destroyed or damaged or that type of thing, then, the guardian could be liable for those actions. So, but generally, a guardian is not liable for actions taken by the ward or protected person themselves. So that's something that understandably would be a concern. A guardian may be removed by the court if they are not properly performing their duties. A successor guardian will be appointed, and a successor guardian may also be appointed if the first guardian resigns or dies. So our special needs, individuals with special needs in many cases are living a long, long time. And so it's not beyond reason to think that they might have 3 or 4 guardians over their lifetime, because individuals with Down syndrome are living into their 70s, this type of thing. And so they could, again, each guardian might serve for 15 or 20 years and they might need 3 or 4 guardians. So there's kind of a process where one guardian may slip out or pass away or no longer be able to serve, and then another guardian would be appointed by the state or by the county, excuse me. So guardianship generally terminates when the protected person reaches age 18. So this is important because for some time there's been, I don't know, a rumor or a thought out there that, wow, wait till 18, get guardianship when they're 16 or when they're 17. But this can backfire in that the standard for guardianship is different for a minor versus an adult. Just like the approval process for SSI is different for a minor than an adult. So if the objective is to have guardianship that's going to last a while, then typically one would want to wait until you're approaching the 18th birthday to petition the county court for the guardianship hearing or proceedings. Otherwise, you may find yourself having to return to court to have the guardianship transferred from that of a minor to that of an adult. One would not want to pay an attorney twice or be inconvenienced to have to go to court a second time. So something to keep in mind. The protected person is no longer incapacitated would be a reason, of course, to terminate the guardianship. Or if they were to get married, protected person dies. In the case of a guardian of the property, the estate is exhausted. So if in essence one was guardian of the estate and then there's no more estate, that might be a reason to terminate the guardianship. The protected person's residence is changed to another state. And we've seen this a number of times. And when the protected person's residence, that doesn't mean they go to visit their aunt or uncle in Phoenix for the summer or perhaps go to stay with a sibling for the holidays. But if literally their address changes, their government issued ID address changes, and if there's a tax return filed, it's filed under the new state. If Medicaid services are changed to a different state, if one really has moved, then guardianship needs to be terminated in the state where it was previously granted and then transferred to the new state of residence. So guardianship can move from state to state. Okay, if there are questions about guardianship, now would be a good time because we're next going to move into alternatives to guardianship. So it is not financially crushing to obtain guardianship. Most families can afford. And if guardianship is being pursued at age 18, the age of majority, then typically, if not before, we're assisting families in applying for SSI at that point, supplemental security income. And supplemental security income will provide a flow of revenue for household expenses. In most cases, that'll go to the parent or parents, assuming that the 18-year-old is living with the parents, and most are Most are still in school, either under a diploma track or certificate track. And if certificate track, then potentially till age 21 or age 22. And so this SSI benefit, in essence, though it comes to the child to defray the cost of food and shelter, it's transferred to the parents. And then the parents, as it becomes their funds, the parents can use it in whatever manner they deem appropriate. It's really there to reimburse for their the share of the mortgage payment, utility bills, food costs, et cetera. But the point I'm making is that the maximum SSI benefit this year is $841 a month. Again, that's $841. And if guardianship is coming up as an issue because they're turning age 18, and also simultaneously you're applying for SSI, the parents could have as much as $841 a month, tax-free, both federal and state, coming in as a result of SSI eligibility. And then those funds could easily enable them to afford an attorney for guardianship, even for estate planning, setting up a special needs trust, et cetera. Most of the attorneys that I work with are very amenable to a payment plan. So if guardianship, as an example, were to be $1,500, then $100 a month for 15 months. And that $100 a month could, again, easily come from the funds the parents receiving from SSI to reimburse them for food and shelter expense. So again, guardianship is not financially crushing. It is affordable in most family situations. But guardianship is not for everyone, and alternatives should certainly be considered. And we can briefly discuss kind of the criteria by which determination is made whether guardianship is appropriate or not. The first and most obvious determination is based on capacity. So when we look at alternatives to guardianship, such as the healthcare representative, the durable power of attorney, these are documents that typically an attorney would draft for the individual with special needs to sign. And an attorney is going to be very keen, if participating in this process, to confirm that the individual signing these documents has the capacity to understand what they're signing. So with a healthcare representative, they are authorizing someone to make healthcare decisions on their behalf if they are unable to. Of course, with the healthcare representative, it explains the circumstances and how the authority transfers to the designated person, et cetera. So that's one example of an alternative to guardianship where the individual with special needs would execute a healthcare representative. A second document is a durable power of attorney. In the event of incapacity, they're authorizing someone to conduct business affairs on their behalf. So, but the key is that they have capacity, that they understand what a durable power of attorney is, what a healthcare representative document is, that type of thing. Need to understand what they're signing. They also need to have the capacity to make a decision on who they are electing. So you see, they need to understand both the document, how it works, and they need to have the capacity to decide who they're selecting to be their healthcare representative or their durable power of attorney. If they lack capacity, then chances are these options are not appropriate, and perhaps guardianship should be considered. But if they can understand the documents and they can make a thoughtful selection as to who's up first, perhaps up second in these various roles, then perhaps executing these documents is a viable option. Another issue that we have to look at is the extent to which there's predictability and that they are able to work with the parents, this type of thing. So if behaviors are not predictable, then this can create a problem because the idea is at the time they lack capacity, the person indicated in the healthcare representative or durable power of attorney would step up and make decisions, et cetera. But this is power sharing, unlike guardianship, where the court appoints the guardian and the power that the guardian has is reinforced by the court. In this case, it's power sharing. And the individual with special needs, when they execute or sign these documents, they're authorizing, not the court. And he who authorizes can unauthorize. And so if they, if shall we say, the relationship is a bit bumpy, or their mood or their outlook on things is not predictable, then these documents that are put into place can be ripped up, can be undone, that type of thing. Who shares power could decide they no longer want to share. And no power is taken away from the individual executing the documents. So just because they execute a healthcare representative or durable power of attorney doesn't mean they've given up any of their power whatsoever. The only circumstance really to where they would not be able to revoke would be indeed if they were at the point of incapacity, meaning, they've had a medical crisis or an auto accident or something, and they can't make these decisions themselves. Then whoever is designated in these documents is certainly the person that's going to step up in that situation. But prior to being in the crisis mode, the individual that executed the document can decide they want to change who these people are. They want to just undo it, tear it up, do away with it, etc. You see trust noted, and trust is a legal document, and creating a trust creates the opportunity for financial resources to be held under a trust arrangement. And so a trust is a tool, and it certainly can be in addition to guardianship, but by setting up a trust, then it could be a part of a plan, an alternative to guardianship, by having their finances handled under the trust arrangement. That trust can be a special needs trust. If we have government benefits involved, then we want to be thoughtful about the resource issue of $2,000 regarding their eligibility for Medicaid waiver services, Medicaid, and SSI. Parental powers at the bottom, just to touch on that. If they are under the age of 18, then, as I said, typically guardianship is not needed. If they are 18, if they're under the age of 18, parents typically have the power. The only circumstance, as I mentioned earlier, would be with the parents still here, is when they may have inherited or received funds, and the parents may need to go to court to be appointed guardian over their estate. All right. Representative payee, the first item mentioned, the representative payee is when a person becomes eligible to receive benefits such as SSI, supplemental security income. And if the individual with special needs starts receiving this benefit, then typically, if they do not have the capacity to manage the SSI benefit themselves, then as a result of that, someone would need to be appointed to take care of their SSI or supplemental security income benefit for them. So usually this takes the form of that individual going to the bank and setting up what's called a representative payee account. The recipient of the income is on the account to receive it, and then most often the parent, who is the representative payee, is on the account in order to be able to transfer funds out of this account. Social Security does electronically monitor Social Security accounts. And so as a result of that, Social Security is keen to see that the funds are actually being used for food and shelter, and that the balance on this account does not exceed $2,000. If the representative payee account goes above $2,000, then they are considered as having excess resources, and they're simply not eligible for SSI. Sometimes it takes Social Security months to figure out that's happened, but they've been known to catch up with situations many months in arrears, and months that typically start with more than $2,000 in a representative payee account, they deem as the month of ineligibility, in which case, as some of you probably know, Social Security comes looking because they want their money back. Important issues as it relates to Social Security. And by the way, SSI usually does not last a lifetime for most recipients. It usually lasts until which time they can either start drawing off of their own Social Security record from part-time employment or that of a parent's record. Being able to draw off of a parent requires that the parent, at least one of their parents, be dead, disabled, or drawing off of retirement benefits. So dead, disabled, or retired. Those are the three triggering events. And in most cases, that transitions the recipient of SSI over to SSDI, Social Security Disability Income, drawing off of, again, their own record or that of a parent. And in many cases, SSI stops at that point, in that the benefit they draw off of themselves, especially off of a parent, will exceed the benefit they've been accustomed to receiving under SSI. Okay, we talked about the healthcare representative, someone that makes healthcare decisions for them if they're unable to for themselves. Again, that and the durable power of attorney is power sharing. So if you have an individual who you simply can't depend upon to stick with their decisions, you may not want the expense of putting these forms in place or documents in place only to have them tear them up, et cetera. So every situation is different. This is why I encourage families to take advantage of the free follow-up consultation that we provide, whenever I speak like this, so that we can personalize the general information we're reviewing to that individual family situation and determine what is an appropriate response. Okay, spending a moment on trust, and we're going to be moving to ABLE account very shortly. But a trust is a relationship where property is held by one party, the trustee, for the benefit of another party, the trust beneficiary. It is created by the owner, also called the settlor, trustor, or grantor, who transfers property to a trustee. The trustee holds that property for the trust's beneficiary, meaning the beneficiary of the trust. Special needs trust is a trust created to benefit a person with special needs, and a special needs trust, or S&T, may receive assets such as inheritance, a court settlement, an insurance claim payment, gifts of money, or life insurance proceeds. So lots of things can go into a special needs trust. Also, retirement funds can go into a special needs trust. So if a parent has a 401k or an IRA, a SIMPLE, a SEP, a Roth, these types of things, then the special needs trust can be listed as a beneficiary. And the financial firm or bank or insurance company can make payment directly to the special needs trust. Protect current and future government benefits, which is huge. The value of government benefits anymore, really substantial. With SSI now at $841 a month, over $10,000 a year, and budgets for waivers, given the family supports waiver budget now pushing up against $20,000 a year. The value of Medicaid for healthcare. Again, these benefits are worth hundreds of thousands of dollars over the lifetime of our children with special needs. And so oftentimes the special needs trust will help protect continued eligibility for these very valuable benefits. The objective being, of course, to leave assets to or gift assets directly to the special needs trust so that they are not seen as a resource for the loved one that has special needs. There are different types of special needs trusts. Let's see here. To date, today's topic doesn't allow us time to go into the different types, but we can have a session down the road if you want. But some of you may have heard of these, what we call third-party special needs trusts and first-party special needs trusts, Miller trusts, and then whether trusts are revocable or irrevocable, whether they are testamentary or living. So there are a variety of different types of special needs trusts and ways to set them up. And again, if that's an interest of yours, just so that you're familiar with terms and things that you hear, this type of thing, happy to have a follow-up session on special needs trusts. It's a fascinating area. To a certain degree, it got started back in 1993 with the Omnibus Budget Reconciliation Act of 1993, 29 years ago. Special needs trusts are simply amazing. They are amazing. All right. I think with that, we will exit this PowerPoint presentation, and we're right on track at 45 minutes from the one before we move to ABLE account. But before we move on to ABLE, any questions anyone would like to ask on the subject of guardianship? Okay, all right. Well, I'm sorry.
It's a very quiet group today.
No problem. Okay, we're going to move on to ABLE accounts. And I love sharing the presentation about ABLE because there is so much more to ABLE than most people realize. So I hope that there's something in the way of new information for everyone with today's ABLE account presentation. Lisa, could you just acknowledge that the ABLE account slide deck is up, that we're seeing the young girl?
Yes.
Wonderful, thank you. All right, again, disclosure, we're not all things to all people, though we strive to help as many people as possible. I think currently we work with somewhere between 2,500 and 3,000 families between Indiana and Kentucky. And so we're so thankful, again, that we can be helpful to so many families as they seek to protect and provide for their loved one with special needs. And I'm so thankful for all of you that are on the Zoom meeting today. Some of you, no doubt, are parents yourselves, but most all of you, of course, are serving the special needs community. And I'm, again, so thankful for you. So I would be remiss if I did not give a big shout out to you as personally as a parent of someone with special needs. So ABLE, standing for Achieving a Better Life Experience, ABLE, ABLE, got started about 6-7 years ago. And a gentleman by the name of Stephen Beck, who is located in Virginia, who had a daughter with Down syndrome, is the one that spearheaded the advocacy to get the ABLE Act passed. It took 7 years, so he started on this back in, I think, 2007-ish, and approximately 7 years later, in 2014, it finally came into law as a part of the Tax Increase Prevention Act of 2014. The law allows eligible individuals with disabilities to have a tax-free savings account. The legislation was modeled after the 529 college savings accounts. Like in Indiana, we have something called College Choice, or in Virginia, there is the College America plan, which I think is the most popular in the country. So the, again, legislation was patterned after the legislation that brought about the 529 college accounts. And so oftentimes ABLE accounts are called 529A, again for 529 ABLE. So why did Mr. Beck feel the need to champion this cause and that type of thing? Well, he had 529 accounts for his other children, but the daughter with Down syndrome was not expected to go to college. And so he did not have a 529 for her, but wanted to save for her. And he was frustrated, of course, when he learned that any savings has to stay under $2,000 to maintain eligibility for SSI, Medicaid, waiver services, etc. So he thought there has to be a better way. And the result of his labor for 7 years brought about ABLE accounts. It is worth noting that he actually passed away on the eve that Congress passed the legislation. And so to honor him and his great effort to bring ABLE account to us, the legislation was renamed the Stephen Beck Jr. Act in his honor. Legislation has been passed in most states. So just like when college accounts, 529 college accounts came about. Not all states had them. Some states used other states' plans, et cetera. So same with ABLE. Most states have them, but not all. North Dakota does not have an ABLE account. They use Minnesota's ABLE account most of the time. But we're probably getting fairly close to 50 states with ABLE accounts now. And some states have tax advantages, just like 529 college accounts. Indiana's does not have a specific tax advantage like the 529 college choice, where there is a 20% state income tax credit. So such a tax credit does not exist with ABLE. However, the ABLE accounts do enjoy a Roth IRA tax treatment, which basically means after tax dollars are deposited, they grow tax-free, and then they distribute, or withdrawals are made tax-free. So those tax advantages are certainly enough to make an ABLE account very attractive from a tax perspective. There is a website, www.able.nrc for National Resource Center .org, which is a clearinghouse for information on ABLE accounts and the various state programs. So ABLE came out at the end of 2014. 3 years later, in 2017, the Tax Cut and Jobs Act brought enhancements to ABLE. They made it better, and we'll talk about some of these. Eligibility for ABLE must be blind or disabled prior to the age of 26. There is an effort afoot to raise that age limit, but until they do, this would not be for someone who had some sort of disabling event at age 30. So for, at least for now, the disability originated prior to age 26 and will result in disability or death, such as spina bifida, hemophilia, muscular dystrophy, and so forth. Can be greater than 26 when opening the account if the disability occurred prior to turning 26. So you don't have to be under 26 to have an ABLE account. Your disability simply needs to have originated prior to age 26. If age criteria is met and an individual is already receiving SSI and or SSDI benefits, the person is automatically eligible. That is, they are disabled prior to 26 and they have met the Social Security standard or criteria for disability. If the age criteria is met and the individual is not receiving SSI, which would be the case for most individuals under the age of 18, then they must meet Social Security's definition and criteria of significant functional limitations and receive a letter of certification from a licensed physician. So there's a way to get the criteria met so that one can have an ABLE account. Maximum annual contribution. Oh, I do apologize. This update came late, but the limit has now been raised to 16,000. So 16,000 is the annual limit now for contributing to an ABLE account. And it's tied into the gifting limit, which at the first of the year did jump up to $16,000. If an individual has an account, then they can contribute up to $16,000 per year. And again, that contribution is after tax dollars. It grows tax-free, it distributes tax-free, that type of thing. As far as overarching maximums, the maximum account balance is $100,000 for SSI recipients. And there is an overarching maximum 529 plan max, which applies to ABLE as well, of $350,000 in Kentucky, $450,000 in Indiana to maintain Medicaid eligibility. So a maximum of $100,000 to maintain SSI eligibility, and a maximum of $450,000 in Indiana to maintain Medicaid eligibility and therefore waiver services. So you have those limits to keep in mind. If SSI recipient's ABLE account goes over $100,000, They do not lose eligibility for SSI. Their benefit is simply suspended until their account balance drops back down under 100,000. So they'd have to spend some money. All right. One ABLE account allowed per person. So unlike 529 college accounts, the consumer with special needs can only have a single account. And it is their account. Grandparents cannot have each grandparent, you know, if you've got 4 grandkids, or I'm sorry, you have 4 grandparents, they cannot each set up an ABLE account for the same grandchild. So the limit is 1 account per individual with a disability. Contributions can be made by anyone, beneficiary, family members, friends, etc., and must be made in cash. By cash, what we mean is check, cash, this type of thing. It cannot be made with property or shares of stock or that type of thing. Deposits to ABLE comes in the form of cash. Okay, tax and penalty-free rollovers of up to 16,000 now from a 529 account where ABLE account holder or family member of the account holder is the 529 account beneficiary. The rollover accounts toward the count toward the annual ABLE, and only 1 rollover allowed per year. So what that means is for a family, as an example, that set up a 529 college account, but it does not appear that it will be used for college, you can do a change of beneficiary to another family member, or if you want those funds to help that particular family member that has special needs, then $529 can be transferred over, I'm sorry, yeah, $529 can be transferred over to ABLE accounts. The main reason for that is that, as you'll see in a subsequent slide, ABLE accounts can be used for a myriad of expenses. They are not in any way limited to just education. So the benefit is that, yeah, they want to be able to use the funds for broader purposes. Rollover accounts toward the annual ABLE contribution. So that means if you can put in 16,000 a year and you do a rollover of 8,000, there'd be another 8,000 available to contribute. Rollover of certain retirement fund accounts may be possible upon termination from employment. This comes up as an issue for individuals with special needs. They get the part-time job at Walmart or some other location. And they have a 401k while they're there. Well, while they're an active employee, it's not considered an asset or a resource of theirs, but when they terminate, it is. And so upon terminating, if they have more than $2,000 in their 401k, we're going to need to do something with it. Putting it in an ABLE account can certainly be an option. At the very bottom, it mentions those that have earned income. So if someone does have earned income, then the potential exists to put in even more. And it's up to now 12,800. So literally with earned income, the total maximum in a calendar year could be up to $28,000, 15 or 16 plus the $12,800 from earned income. So the ceiling is quite high. One, again, would want to be careful though, because the $100,000 maximum to maintain SSI eligibility, and in Indiana, $450,000 to maintain Medicaid. And there you see it. There you see the broad range of expenses that ABLE accounts can cover. It, again, very thorough, very, very broad. And many people, again, want to move from a 529 environment to an ABLE environment because there are so many ways for the individual with special needs to benefit from an ABLE account or the savings or accumulation in an ABLE account. Again, if it grows tax-free, it distributes tax-free. Okay. One thing that should be mentioned about ABLE, the Medicaid payback. ABLE account does provide for a state to place a Medicaid lien on an account. This would mean that if something happened to the ABLE account holder, the individual with special needs, the potential exists that the state would step in and seek to reimburse themselves for Medicaid benefits afforded the individual from the time the ABLE account was set up. All right, so ABLE account programs are developed and managed on the state level. Here in Indiana, we have something called Invest ABLE, IN for Indiana, VEST, and then ABLE, if you run it all together, investable. States can decide to contract with another state. So as an example, Kentucky contracts with Ohio for the stable account. The ABLE account or ABLE Act requires that any state that establishes a plan must provide adequate safeguards to prevent excess contributions. Individual can enroll in any state's ABLE program. So you're not limited to Indiana or that type of thing. We use quite a bit of the Virginia ABLE America account, which is managed by American funds. Excellent investment returns, and they do a great job. So the state determines the enrollment process. Enrollment and maintenance of the account is primarily done through the individual state ABLE program. Some allow via mail or fax. ABLE America is set up and serviced by an advisor. So if I set up an ABLE account for someone using the Virginia account, then I'll be able to service it, take care of it, answer questions, and help with disbursements from it and receiving deposits into it and so forth. Depending upon the state, there may be a minimum contribution to open the account as well as an annual maintenance and or underlying investment fees. Okay. In a moment, we'll have some examples of how ABLE accounts can be extremely helpful. An ABLE account may not be the best vehicle if. So these are situations where we may not want to use ABLE, and then we'll talk about situations that ABLE is really a good pair for. So inheritances, settlements, judgments, or contributions from family beneficiaries exceed the maximum annual contribution limit. So if someone with special needs inherits $25,000 as an example, then that's $9,000 more than the $16,000 allowed, meaning the ABLE may not be the best option. Contributions are not coming from the individual with a disability and therefore could go to a third-party trust. So my grandparents, if they want to do something to be helpful, then if they were to make a deposit into a third-party special needs trust instead, you would avoid the Medicaid payback clause. So beneficiary with disability whose origin or diagnosis came after their 26th birthday, they're not eligible. And then the beneficiary cannot make financial decisions or ABLE account can be used in combination with other savings vehicles such as special needs trusts. So different tools in our tool chest. And now we get into examples, and we have 3 here and then 2 on the next page. So this is a lot of fun to look at how ABLE account can really help. So better suited for small settlements, unexpected inheritances, or savings of the consumer. So this will kind of help see where ABLE fits in. So think of it as a put and take or save and spend type of account, an ABLE account. Examples where an ABLE account can be very useful. Example 1, grandparent dies and leaves. And by the way, all the examples today are based on real life stories with the many hundreds of families that I work with. There are so many compelling stories. So I'm so thankful for these families. So I just pulled a few of their stories to tell in examples here. So grandparent dies and leaves $10,000 directly to each grandchild. For the grandchild with special needs, it must be spent, used to prepay final expenses, or deposited into an ABLE account. So depositing it into an ABLE account will enable the funds to be preserved and used another day when the money is needed. So I think that, that's an example where it's like, you're excited because the grandparents left money to your child with special needs. And then you find out that $10,000 may mean the loss of tens of thousands of dollars of Medicaid and waiver services, et cetera. So what a great thing it is to be able to set up an ABLE account and throw the $10,000 into the ABLE account to be used someday in the future, let it grow tax-free, and be able to put the situation together, through the ABLE account to maintain the government benefits, et cetera. Okay, let's move on to example number 2. So again, example 1 was the unexpected inheritance. Example 2, a school bus incident. And this really happened. So a non-ambulatory girl went to school in a wheelchair. And unfortunately, the wheelchair was not appropriately restrained. And so when the school bus door was opened, the wheelchair literally rolled out of the bus, and the young girl face planted on the asphalt. So that was a really difficult situation. There was litigation, eventually a settlement for $15,000, and they were able to set up an ABLE account, deposit the $15,000 settlement in the ABLE account, and the young girl was able to retain all of her government benefits. Example 3, an individual with special needs gets a job resulting in earned income. They want to save some of it for a vacation, furniture, additional schooling, vehicle, et cetera, while maintaining SSI, Medicaid, Medicaid waiver, et cetera. An ABLE account allows for funds to accumulate for future use without being subject to the $2,000 resource limit. So in that situation, one could take their earnings and accumulate it in an ABLE to create security for their future without what's in the ABLE being treated as a resource and causing loss of benefits. Oh, well, those are 3 examples. Let's move on to a couple more here. ABLE accounts within limitations can address resource issues, sweeping the inheritance, legal settlement, or paycheck. As we just talked about in the previous slide, 529 savings or investment account into an ABLE account, the consumer is back under the $2,000 resource limit, and all is saved. However, what an ABLE account won't fix are income issues. And these 2 examples are talking about income. So example number 1, consumer age 22 is receiving SSI and has a part-time job earning $500 a month. Placing his or her $500 paycheck in an ABLE account will not allow him or her to avoid the reduction in SSI. So the way SSI is calculated, and you might be aware of this, but in the case where there's $500 in earnings, the first $85 is overlooked, and then the remaining $415 in earnings is divided in half. So that would provide for an SSI benefit reduction of $207.50. The ABLE account will, however, help to keep the bank or representative payee account under $2,000. So bottom line is, setting up an ABLE account would not keep Social Security from reducing the SSI benefit amount because of earned income, but it would help the consumer keep their assets and resources under $2,000, since the ABLE does not count against them. Example 2, consumer age 35 is receiving $500 a month SSDI from their own record of employment. They also receive adult child benefits of $1,000 a month from their parents' record. They continue to work, earning $900 a month. They can save up to $25,800 a year to an ABLE account to keep countable resources under $2,000, but this will not fix their exceeding the monthly maximum for disability Medicaid. So again, the ABLE account's great for resource issues, not so good for income issues. And in this particular case, example number 2 here, we would want to look at a Miller Trust, because a Miller Trust is a type of special needs trust that enables income to be set aside for future use while maintaining eligibility for Medicaid, et cetera. So, all right. If there are questions, feel free to put them into chat. better suited for small settlements, unexpected inheritances, or whoops, let's move forward. I'm sorry. And there we go with the contact information I promised to provide. We do have about 15 minutes left, so feel free to take a picture of contact information. I'm happy to provide a free follow-up consultation. Again, no charge. We typically set aside an hour to an hour and a half for each family, and we're able to drill deep into the subject matter that we touched on today as to how it might help the family in their special needs journey. Added to the chat is the link for the evaluation for today's session. So thank you so much for that. Again, I will leave my contact information up for just a moment, and then I will stop sharing screen and see if anyone has questions about the topic covered today or any other special needs topic. So I don't see any questions in there. At any rate, Lisa, I yield back to you. And I want to thank you for what you and your wonderful organization do. And I'm so thankful for the opportunity to share today, and appreciate you providing this platform that I might provide helpful information.
Well, thank you, Gordon. I really appreciate you coming and talking with us. And thanks to all of you who have joined us this afternoon. I just wanted to do a quick reminder that Gordon will be back on March 22nd at 2 p.m. And I believe then the topic is special needs trusts. And don't forget to fill out your evaluation. The link is in that chat box. And I think that's all I have for today. If no one has any questions, we can be done.
All right. Thanks, everybody. Appreciate you so much. We'll see you next month.